So, copyright is a legal right granted to the creators of original works, giving them exclusive control over how their works are used and distributed. The control lasts for a specific period of time, then it enters the public domain, allowing anyone to use it freely. So, in essence, copyright protects the expression of ideas rather than the ideas themselves. And so you can have a great idea for a story, but if you don't actually express it in a written form, or then you are not invoking your right to copyright. You will not be protected under the law. This means while there may be unique ways and ideas expressed in a book, song, or film that can be copyrighted, the underlying idea or concept cannot be copywritten. So think about some of those ideas and whatnot that you might have, and consider putting them into a fixed medium, being, put the idea down on paper. So you are granted automatic protections. So as soon as the work is created into a fixed, tangible medium, so it's written down, it's recorded, or otherwise documented, you may want to consider, documenting, or if it's a Word document, maybe you can email it to yourself periodically just to kind of create a paper trail that kind of fixes that medium in time. Most, like if you're using, let's say, Word or whatnot, it puts a date with it, so you can see when the date it was created and use that. There is no need for formal registration, although registration can provide additional legal benefits, and we will get into that in a later video. So you have exclusive rights as the creator to reproduction. So you have the right to make as many copies of that work that you want to make. Remember whenever I talked about the vanity presses? If you don't have your copyright and you signed it over to a vanity press, it means that, if they decide they're only going to print 500 copies and that's all that they're going to print, then you sell those 500 copies and you want more, you don't have the right to reproduce that work unless you find out a way to recover that copyright from the vanity press. You have the right to distribution. So you have the right to sell that work in whatever means. You can sell it to, a bookstore, and you can sell it wholesale and then they sell it. You can sell it in person at different events. You have the right to do that. It's your work. Public performance, you have the right to perform the work publicly. If it's, music, or it's a screenplay, or something that is visual. You also have the right to public display. So you have the right to display any of your work publicly. This is typically, with your artwork. So you could put your artwork in a gallery somewhere. You have the right to do that. And you have the right to create derivative works. So you can do new works based on the original. So you can make adaptations. You can have translations of that into different languages. And just keep in mind that there are limitations and durations to the length of the copyright. It doesn't last indefinitely. And we will go over what the details are as far as the duration. And there is transferability. So like I said, you could potentially transfer your copyright to like a vanity press, and it can be, then it becomes their intellectual property and not really yours anymore. Or you can choose to license it. So if you wanted to allow somebody, let's say you created a world and you want someone, somebody asks you, hey, I really, really enjoy this world. May I write in this world? You can give them licensing options that can be allowed to write in that world. So basically, you're selling or granting permission for others to use the work under specific conditions. Again, you want to have a strict contract on how that work is to be used, what it can be used, what can't be used. I think you probably want some sort of process in place that you can review that prior to publication of any kind. And you really need to know the intent of whoever you're selling the license to. Are they planning, what are they planning to do with their permissions to license and create works under your intellectual property, and making sure that they don't do something with your intellectual property that you had no intentions. What if they go out and they do something and it's just perceived horribly, and then everybody's pointing the finger back at you as being responsible, because they are in essence a reflection of your original intellectual property because you allowed it. So you want to make sure that you keep control. So what can copyright cover? Obviously, literary works. So you can do books, articles, poems, essays, any other written content. So it could be plays, scripts, etc. Software code is also included under copyright law. Musical works, both in composition, so the actual sheet music, the actual music, and then also lyrics can be copywritten, and the sound recordings are protected by copyright. So anything from sheet music to recorded songs. Dramatic works, plays, scripts, screenplays, and other works intended for performance fall under the category of dramatic works. Choreography. Original choreography, when noted and recorded, can be protected by copyright. Pictorial, graphic, and sculptural work includes paintings, drawings, sculptures, photographs, audio-visual are protected under copyright law. Architectural work, so the designs of the buildings are covered. Computer programs, like we said, software is also included in this. It's protected as a literary work. It is in a written medium. It just is in a different language. It's in computer language. And there are other works that can be copywritten as well. Lectures, sermons, public addresses, provided that they're fixed in a tangible medium. So maybe if they're written or recorded. So you have to have a paper trail, because if you would end up going to court, you can't just say, well, I wrote this. Okay, well, where is your documentation? How can you prove to me that you wrote it? So you need to be able to provide something as proof that it is in fact yours, making sure that there's some kind of date on there, etc. So we did talk about other forms of protecting your intellectual property. Patents are typically, they give inventors exclusive rights. Trademarks protect brand names, logos, slogans, and other identifiers that distinguish goods and services in the marketplace. And trademarks can actually be indefinitely, as long as they are in use and properly maintained. Trademarks or trade secrets, you can protect confidential business information such as formulas, practices, and processes that provide a competitive edge. Trade secrets can last for as long as the information remains secret. So as long as it stays under wraps, you can have that protection. Design rights protect the visual design of objects that are not purely utilitarian, such as the shape and appearance of a product. So that's just kind of the copyright law in a nutshell on what protections that it gives, what it applies to, and different ways, trying to decide what works for you. For writers, copyright is going to be the most, I think it's going to be probably the only intellectual property protection that's going to apply to literary works.